Hello friends, welcome to Lawyer's Kingdom. Data protection is a complex and significant aspect of ensuring privacy and security in the digital age. In India, the laws and regulations governing data protection have evolved over time to address the growing concerns related to the handling and misuse of personal data. Let's delve into the detailed aspects of data protection in India. Information Technology Act 2000. The Information Technology Act 2000 Act serves as the foundation for addressing cybercrime and data protection in India. It encompasses various sections that outline offences and penalties related to unauthorized access, hacking, data theft, and spreading of malware. The Act also includes provisions for the protection of personal data. Personal Data Protection Bill 2019. The Personal Data Protection Bill 2019 is a proposed legislation aimed at providing comprehensive protection for personal data in India. If enacted, it will establish the Data Protection Authority of India, DPA, responsible for enforcing the law and overseeing data protection activities. The bill emphasizes the importance of obtaining consent from individuals before collecting or processing their personal data. It also grants individuals certain rights regarding the control and protection of their data. Collection of personal data. Businesses and organizations must adhere to certain principles when collecting personal data. They should obtain explicit and informed consent from individuals, ensuring that the consent is freely given, specific, and unambiguous. The purpose for collecting the data should be clearly communicated to the individual. Use and disclosure of personal data. Personal data should be used only for the purposes for which it was collected, and businesses should not use the data for any other unrelated purposes without obtaining additional consent. Similarly, disclosing personal data to third parties should be done with the explicit consent of the individual, unless required by law or in certain exceptional circumstances. Retention and security of personal data. Businesses should retain personal data only for as long as necessary to fulfill the purposes for which it was collected. Once the data is no longer required, it should be securely deleted or anonymized to prevent unauthorized access or misuse. Adequate security measures should be implemented to protect personal data from unauthorized access, use, disclosure, alteration, or destruction. Data Protection Authority of India (DPA). The proposed Data Protection Authority of India (DPA) will be responsible for enforcing the provisions of the Personal Data Protection Bill 2019. The DPA will have powers to investigate data breaches, issue guidelines, impose penalties for non-compliance, and promote awareness about data protection. Supreme Court and Data Protection. The Supreme Court of India has played a crucial role in defining and reinforcing the right to privacy as a fundamental right under the Indian Constitution. In the case of Justice K.S. Puttaswamy v. Union of India, the Supreme Court affirmed that individuals have a fundamental right to protect their personal information from unauthorized access and use. Recent developments and judgments. The Supreme Court has delivered judgments that have shaped the data protection landscape in India. For instance, in the Aadhaar privacy case, the court upheld the constitutional validity of the Aadhaar scheme but imposed certain restrictions on its usage to safeguard individual privacy. Case study: Data Protection Law in India. In a recent case, a major financial institution in India experienced a significant data breach, resulting in the unauthorized access and theft of sensitive customer information. The breach exposed personal data, including names, addresses, and financial details of thousands of individuals. The incident raised concerns about the company's compliance with data protection laws and its responsibility to safeguard customer data. The affected individuals filed a complaint, and the matter was taken to the Data Protection Authority of India (DPA) for investigation. The DPA found the institution in violation of multiple sections of the Personal Data Protection Bill, 2019, and imposed penalties accordingly. The case highlighted the need for stringent data protection measures, the consequences of non-compliance, and the importance of holding organizations accountable for safeguarding personal data. In conclusion, data protection laws in India aim to protect personal data from unauthorized access and misuse. The Act and the proposed Personal Data Protection Bill, 2019, provide a legal framework for businesses and individuals to ensure the responsible handling of personal data. Adhering to these laws, implementing security measures, and respecting individuals' privacy rights are crucial for fostering a safe and secure digital environment in India. To know more, please like, share, and subscribe our channel.